Well, hello, everybody. My name is Jeff Whalley with Whalley Law. I manage a law office that operates in the west side of Washington State and the east side of Washington State out of Spokane and Tacoma. We practice primarily personal injury, domestic law, family law, and some estate planning. Today, I'm going to talk to you about a primer related to simply filing motions, how to file motions, and what motions really are. And to start, it's important to understand that our court system has several types of rules. The underlying rules are the civil rules, and those are statewide. And then within each jurisdiction, you have what they call local rules. So whatever county it is that you have a matter pending, it is very important that you not only understand the state rules, which we call the civil rules, along with the local rules, because the local rules will typically either narrow the scope of the state rule. That means it will give you some specific information as to how that court applies the civil rule. And it's very important when discussing motion practice because every county has different rules related to motion practice. And so understanding the local rules as to when your motion is due, how much time you must provide the other party to respond, how much time you have to reply to their response, and when the matter is heard and how it's heard is very important. It's important for several factors, and the most is knowing your audience. And so the purpose of a motion is simply you are asking the court for relief, or you're asking them to do something for you. And in each type of law that you practice, it's a little different. In civil law, you typically have to draft your own motions from scratch. And most motions are not templates. In domestic, or more commonly known as family law cases, there's actually requirements that you use the templates. Those templates are pretty easy to follow. They are a box checking, and I will get into in future sessions, get into the very specifics of different types of motions and what you need to do in order to give yourself the best chance of being successful before the court. So once you figure out what court you're in, typically it's going to be a superior court, but sometimes it may be a district court. You need to then look at the state rule, state civil rules, so whether or not it's limited jurisdiction or it's a superior court. And then on top of that, find that county in the rule book, or you can find it online. And at that point, identify what local rules will apply and are applicable to your matter. The common rule for motion practice is Civil Rule 7. And Civil Rule 7, in essence, states that you must state the relief you're asking the court to grant, meaning what do you want the judge to do for you? You need to state with specificity what rule, basically, what authority or mechanism or rule does a court rely upon for you to grant you the relief that you're asking for? And then the basis thereof, right? So what is your basis for that? And I can tell you that from practicing all across Washington State, you find that each superior court, each courtroom jurisdiction is different. Each judge is different. The way they handle their courtroom, the way they handle their motions, and the way they interpret the law and rules are all different. They all are similar in essence of understanding what exactly their role is. But at times, some judicial officers believe they have a lot more latitude to grant relief that may or may not be requested within your motion. Other judges or judicial officers believe that Civil Rule 7 really restricts them from expanding what it is that you are requesting. There have been many times, and it seems to be more prevalent nowadays, in that people simply file a motion asking for a certain type of relief, but yet they want additional relief as well. And so the courts have to determine whether or not they have provided enough information for the responding party to be able to grant that relief. And what I mean by that is sometimes people will file a motion and they ask for a very specific relief, let's say regarding some sort of property. But within their fact pattern, there's some other issues that they want the court to decide. And the court sometimes will say, yes, they provided that information because this is a notice pleading state. That's enough for them to simply make that ruling. Others will say, we construe that Civil Rule 7 states that you must state with specificity the relief you want, and so they deny it because they don't think it's properly before the court. Ultimately, it's going to fall upon the feet of the judicial officer who you're in front of, and they all treat it differently. And so that's why it's important to understand motions and what you are trying to achieve. So the first part of the motion is obviously read the civil rules, understand Civil Rule 7, and there's some other rules that may be applicable, and we'll cover those in future sessions related to specific motions that you might file. And so once you understand Rule 7, you'll actually learn how much time you have to provide to another party. Now, typically, it's not every county, but typically it's approximately about 14 days. It's important to read the language as well of the rule because there's a difference between judicial days and simply days, right? Judicial days mean holidays in which you have to make sure that a federal holiday does not fall within that time period of 14 days, so you know exactly what the response date is. A common flaw with a lot of motions during the holidays or around a federal holiday is people fail to calculate that day within their when they note the hearing to the date of the hearing, and so it's untimely. And you know, a lot of people think that you can simply defeat a motion because it's untimely. Kind of that's true, but really what happens is it's just simply the relief gets delayed, and so the moving party needs to refile their note to provide sufficient time for the responding party. So there's a couple of things that I've stated that I want to clarify. So in motion practice, in civil rules, you have, or excuse me, civil cases, you have a plaintiff and defendant. In domestic cases, you have a petitioner and respondent. Those identify the parties based on the caption. Then in motion practice, you have the moving party, which is typically the party who has filed the motion, and the responding party. And that's the party who is responding to the motion. In most jurisdictions, they allow for the moving party to argue first when it comes to time for hear the motion. The responding party then gets an opportunity to respond. And if the moving party reserved any time, they then get to reply and have the last word. That's the same as the motion practice itself. And so in order to start filing a motion, you must first draft the motion. And so it's important to understand what exactly you are asking for and why, and then whether or not you have a legal basis for that request. So in order to draft the motion, you must make sure first and foremost you have the correct caption on your pleading. And that includes the case number, the plaintiff or the petitioner, and then the respondent or defendant. So that way the motion gets filed in the correct case. Once you do that, it's important to start the motion with exactly what you're asking for, who you are, and what relief you're asking from the court. You have to keep in mind that our judicial officers are overworked and they see hundreds of pages of pleadings every night that they have to sort through and get an understanding and then be prepared to make a ruling based on the laws and the facts as pled. So make sure that you are very concise and you're very clear in your first paragraph of your motion telling the court exactly what it is that you want and what your basis is for getting that, along with why. Once you've established that, that allows the judicial officer, when they review it, to kind of give it the first impression and think, okay, this is what they're asking for, and this is why. Either they're going to agree or disagree, but then under it, lay out the issues as to what are the questions the court needs to answer, and then lay out your facts and how you believe the court has the authority and should rule in your favor to grant the relief that you want. Now, there's several types of motions out there. Practicing in family law, there's actually a tremendous amount of motions that aren't actually included in the civil rules, that practitioners and pro se litigants simply throw before the court because they need the relief. And so you're not going to find them in the civil rules. You're not going to find them necessarily in the case law. It's just that our lives as humans, there are scenarios that come up that have not been resolved before. All of those motions are motions for temporary orders, typically. And the commissioners will hear those, and they will hear the facts and the basis for why you're requesting relief. And their duty prior to trial is to make sure that they maintain the case, the assets and debts, along with the best interest of the children, until it gets to trial. And so sometimes people will file motions related to property, debts, children that simply are not, you may not see a rule that specifically states this is what you do for that. However, the one rule that is, I think, most important for people to understand, that if you file a motion and it is heard and the court does not rule in your favor in a family law case and a commissioner's heard it, it's a motion for revision. That means you're asking the presiding judge to revise the ruling of a commissioner. And I'll take a step back so you can understand how motions work. So after you've drafted your motion, there's a couple things that you need to have with it. One is the motion includes the facts and the authority or the legal authority and what you're requesting. Included with that should be a declaration sworn under the penalty of perjury that asserts the facts to support the motion. That can either be from the party or maybe a third party or an expert witness, all of which that are relevant to the motion. The court never wants to hear the declarations from third parties who have heard everything from you or from a friend. All the declarations should be firsthand knowledge to support the motion. And then also you need to file what's called a note. A note for motion is essentially just a scheduling document. Based on the local rule and the time frame that's allowed for motions, you need to file a note with the court, which then allows the clerk to schedule your motion. And you need to file your note, your motion, your declaration, and any supporting documents. That could be either other declarations or exhibits, all at the same time. And at that time, not only do you file with the court, you also are required in most counties to submit what they call bench copies or working copies. And those are the copies that the judicial officer reviews. And then at the same time, on the same date, you're also required to serve or provide the opposing party with all of the documents that you want the court to consider. Very few instances are there exceptions to that rule. And so generally it's normal to understand, or excuse me, you should understand that having a motion on sensitive material is typically going to put it in the public realm. And so what you say, the evidence you provide, in most instances is not going to be sealed and will be a public document if somebody wanted to dig it out and look at it. All of that information has to be provided to the non-moving party. Generally, Most counties now have gone to electronic system, so it's important that you sign up for, like, say, Pierce County, there's links. Sign up for the online platform that allows you to access your case file. It allows you to see what has been filed. Other counties utilize Odyssey, and if you have a membership for that county, you typically can get access to your documents as well. Counties like King County have a different system, and all of these platforms for the court to hold their dockets and the case files electronically typically cost some money for copies, and so you need to be prepared to be organized so you maintain your copies and don't have to pay for duplicates. Once you have served the other party with your motion, declaration, and note for hearing, you want to make sure you have proof of that. In case the judicial officer asks you if you have a receipt for, or what they call either proof of mailing or proof of service for that note, motion, declaration, and supporting documents. Once they have been served, they then typically have to respond in a certain period. They will send or should send you their responsive declaration, any supporting documents, and typically a proposed order on their date that it's due. It is important to look at the rule for the county because every county has a different filing deadline. Some deadlines are noon, several days before the hearing date. Some deadlines are 4:30 before the deadline. In federal court, I believe the deadline is typically midnight. And so it's important to understand how much time you have in order to file. Now, this motion practice that I talk about is a very general, over the top, kind of top of the trees discussion, because it's also applicable to administrative actions. It's applicable to criminal actions. It's applicable to pretty much any tribunal that you may find yourself in, which is you have to provide a note, meaning you have to schedule the hearing date and time. You have to provide the motion, which means you have to provide the document which states what you're asking for, why you're asking for it, and the authority the court has to grant that relief. And then you have to provide the facts or the declarations and supporting documents to support what you're asking for. The respondent or responding party must then always respond. And this is very important to make sure that you keep track of your time and the time frame in which the response is due, because generally you will not have much time to reply to a response. That means get the last word in. Additionally, a lot of counties have a local rule which strictly limits the amount of information you can provide on what they call strict reply. And your reply or strict reply is supposed to only address the issues that were addressed in the response. It's not to bring in new evidence. If you try to bring in new evidence or new facts or new allegations during that strict reply, there's a chance that the other party requests a continuance to address those issues or even ask the court to strike those issues. And so once you have provided a strict reply, it gets filed. You got to again make sure the court gets working copies or bench copies prior, as soon as you file, make sure you're timely, along with a proposed order. Then it's time for the oral argument. And the oral argument typically means you come to court. This day and age, in some counties, you can appear via Zoom. Now, I have found in the counties that I regularly appear in that the judges' dockets are in person, the commissioner dockets are virtual. However, there are several judicial officers or presiding judges that do allow for virtual proceedings. In motion practice, it's also important to think about your presentation. And when you lay out your motion, you want to make sure that it's succinct and that it doesn't just simply ramble on. that you have identified exactly the facts that are important to support your case, while also addressing the counterpoints from the responding party. Generally, the court's going to look at how did you reply to the response? Do you just ignore it? Or did you have evidence to defeat the points that they're making? When you get into court, whether it be virtually or in person, then it's your time to not simply regurgitate what you wrote on paper, because you have to assume that the judicial officers have read that motion and they understand your position. Ultimately, it is to hit the high points and drive home the details of the counterpoints that were made by the responding party. Be confident, and most importantly, there's nothing to worry about going into court. I find that the most practitioners and pro se individuals have difficulty coming into court because they're nervous about what a judge is doing or is going to do. You have to approach a motion practice simply as a conversation. Some people get a little more emotional than others. Some have a little more theatrics than others because they're comfortable in that space. But all you're doing is essentially trying to educate the judge on the facts of your case and why the law supports your position. It's a conversation, it's a discussion. And there are sometimes the court's going to agree with you, and sometimes they're not going to agree with you. But ultimately, the motion practice should be refined to a skill so that way you feel comfortable trying to address any of the outstanding issues you have with your case in front of the court. That does not mean the court's going to always agree with you. But you want to make sure that what you have before the court is procedurally correct. Because if there's a procedural flaw, it's likely that you're not even heard and that now you have issues because your matter, what they call not properly before the court. And so looking at Civil Rule 7, make sure that you go through and you provide everything that is required of the Civil Rule. Then additionally, make sure that you have the facts that support your case. Meaning, if you're asking for, let's say in a family law case, you're asking for the court to adopt a parenting plan. Well, you want to make sure that you have the evidence that supports it is in the best interest of the child to have visitation according to your proposed parenting plan. And that means if there's issues with the other parent, you need to provide evidence of that. People come before the court and say, the parenting plan is not in the best interest of the children. Well, that doesn't help the judicial officer. They need to know why. And maybe that is because the other parent has mental health issues. And so you may need to file some medical documentation under seal to show the court your concerns as a parent and why it would be in the best interest of the child to adopt your parenting plan. However, if you do not note the hearing properly, you do not support your motion properly, or you don't file the correct documentation, including bench copies or what they call working copies, your matter may not be heard. So it's important to understand the basics of motion practice so that way you can move through the court process and only worry about the merits. I do understand as a practitioner that people get extremely nervous about how to file motions. And on the flip side of it is the court wants everybody to be proficient at it as well, because it makes their life a lot easier knowing that everything's being filed properly, that they're getting the exact information they need in order to make the decision for you. And then from there, you're able to move through these matters. And typically it helps get matters resolved because you're reducing the issues of the case with the decision from the court. And so motion practice is very important to understand if you're going to either handle your own case or you're handling a case of a client, because you need to know, how does the court like the materials and what is the expectation following the motion. And again, this is a part of a series, and so I'm going to deep dive into it and provide materials along with a PowerPoint presentation to break down motion practice. But the last part of motion practice that you must understand is the orders and presentation of orders. So you've drafted your motion, you have filed your motion, you've served your motion on the other side, you then presented your argument, and the court has made a ruling, and then what happens next? Well, what happens next after you give your 10-minute argument or 5-minute, depending on the court, in some cases 30 minutes, the court will then need to reduce their ruling to writing, and that is an order. Again, in civil law, civil cases, typically those courts will require the prevailing party or even the moving party to provide an order that's drafted. Those typically are not formal orders. They need to be drafted based on your request from the court and then reflecting what the court's ruling was on those requests, along with including findings and why the court came to the conclusion or order that they did. And then once you have that, there is what's called a presentation hearing. And this is what's different in all counties. In some counties, the court wants those orders that very day. And that's because they want to make sure that the ruling is memorialized immediately. In longer, more complex cases, typically they will provide what they call a presentation date. And that's for the two parties or two councils to collaborate and draft an order that reflects the ruling, not what the parties agreed to or disagreed to, but simply what the court said, what their order was, and reduce that to writing. And then the parties sign off on it and present it to the court for the court to then add its signature. If there's an issue with what each party heard related to the ruling of the court, the presentation date is the time where the moving party typically provides their proposed order, basically that's supposed to reflect the court's ruling. The responding party would then, or non-prevailing party would then provide their objections to that order. And that's not to say I disagree with the court's ruling on the motion, but it's to say the court did not make this ruling. Once the court has made its oral ruling, that motion has been heard, and it's now time to enter orders that reflect the court's ruling, not to try to change it. And once orders have been put in place, then you have some significant deadlines related to appeals. And typically that can be a motion for reconsideration, which asks the judicial officer to reconsider their ruling. There's a motion for revision, which is a mechanism that requests that the presiding judge of the case or assigned judge would hear the same matter that the commissioner heard, and that you're asking the judge to revise the commissioner's ruling. And then you have your appeal deadline, 30 days, in order to have an appellate court hear the basically your dispute on the motion. And so generally motion practice is very important to understand, because once you understand the basics of it, which is I need a note, so I need to schedule it. I need to have the motion, which asks the court what I'm asking for and why. And then you have a declaration under the penalty of perjury that supports and provides the factual information and evidence or exhibits attached to support that motion. Once you have that in the timing, you're well on your way to being successful with motion practice. Then you just need to effectively work on your craft as your presentation and telling the court why you should get what you're requesting. And once you do that, if there is any adversity or ruling against you, then you know how to file another motion in order to try to overcome the initial ruling. Now, I say that, and again, I'll get into motion practice here in depth, in the coming days. But it is important to understand that you do not want to file too many motions. And the most common thing I see when somebody is pro se is they feel like they can just simply file motion after motion after motion after motion. And they're asking for the same relief, maybe using different language. That is not effective. And the reason it's not effective is because the court doesn't want to hear the same motion more than once or twice or three times. And asking for the relief that's already been ruled upon does not put you in good light with the judicial officer. Ultimately, it makes them feel like you just simply won't listen to the court's ruling. And so it's important to understand that when you set off to file your initial motion, that it's well thought out, that you have provided all the evidence that you need, and that it's in a nice package to be filed with the court. And so they have everything and anything related to those issues, and they can make a ruling in your favor. Now, remember, look at those local rules, because in addition to the timing, there are limitations on the number of pages that you can provide to the court. And so it is important to be succinct, to provide the necessary evidence and not unnecessary evidence. Providing more is not always better. And that, most importantly, make sure that you have a solid foundation as to the relief that you're requesting. Don't go before the court asking for relief on a motion simply because you're upset. I don't agree with it. I don't agree with is not a good legal basis for a motion. And so if you have any questions about motions or relief, there are some very great organizations out there to help. Tacoma Pro Bono is a great organization. You have a family law court facilitator in almost every courtroom in the state. They are great, great resources for you to find out in a domestic case or family law case as to whether you should move forward with something. There's a lot of support out there for people who are trying to file, other motions and in the civil realm. And so make sure that you do your work first, do your research, and understand what your relief is and why the court can grant that, and then proceed forward with confidence. If anybody has any questions on motion practice, feel free to reach out. We'd be happy to help you at any time.